So, Michele, before we broke, you were basically outlining to us the broader processes of how cases get to the Supreme Court, the strategies that, and just the idea that these are strategized. It's not random. The justices have an agenda. They see areas of the law that they think they can impact or want to change, and advocates on both the liberal and the conservative side try and start cases and find plaintiffs that they think will go up the food chain, as it were, and might be the kind of case that a Supreme Court justice is interested in looking at, and one that could actually change some law. And you were specifically, I mean, we talk a lot about the idea of certainly Donald Trump is claiming he would appoint somebody who would overturn Roe v. Wade. We know issues of Second Amendment have come up, but there are other issues. We were talking about labor law, essentially, and issues, courts that affect both consumers and workers. Tell us about the idea of class action. How would Donald Trump, I mean, why, and I think our audience is fairly savvy about this, probably more so than most, because Mike Papantonio, of course, does a lot of these type of cases. But why are class action suits important to workers and to consumers?
Sure. Well, they're a very valuable tool. There are two sort of primary reasons. One is a lot of these claims on their own are too small to justify the expense of bringing them to court. So they might have a lot of value to the individual worker or the individual consumer, but the money at stake is not enough to hire a lawyer, to pay for a lawyer, or for a lawyer to see it worth their time. So by aggregating relatively small claims, important issues get litigated. At the same time, it's a lot more efficient for a court to hear a lot of smaller claims at one time rather than independently, separately. So it definitely promotes judicial economy to have class actions.
All right, and so what's the threat to class action that a Trump presidency could present?
Well, there definitely, Justice Scalia was very skeptical of class actions and was part of a lot of rulings that limited their efficacy, and it's likely that another justice in that mold will use whatever tools are available to further limit class actions as an option for consumers and workers.
Tell us about Walmart versus Dukes so that people get an idea of why this is founded more in an ideological perspective than one that is legal. Or is that even accurate to say?
No, I think it's accurate, although, the justices don't see themselves in partisan terms. But it was a 5-4 decision. Justice Scalia wrote it. So again, you can see the difference that just, one justice can make. And in that decision, past and present female workers of Walmart sued Walmart for paying and promoting them less than their male counterparts. It was a very large class action of over 1 million workers. And Justice Scalia said that the class action tool could not be used in that case. It's somewhat complicated, but the gist is that Walmart was just too big to sue. He said you can't find among so many people a common basis that explains why women were making less money. Okay, and he just ridiculed the idea that such a big company like Walmart would engage in a strategy of company-wide discrimination. In dissent, Ruth Ginsburg wrote the dissent. She explained quite clearly, to the contrary, that discrimination is actually most likely to flourish in the type of discretionary systems that Walmart uses. And the words we've heard a lot lately about implicit bias were part of what she was trying to explain. She was trying to explain that it's not that Walmart supervisors are evil, okay, but that through the process of implicit bias and subconscious assumptions about women as workers, women were getting the short end of the stick. And when Justice Scalia was looking at employment law, he's really only seeing it as a tool to go after bad apples. And he just doesn't believe that such a big company could have so many bad apples. So one way to think about it is in a lot of these large employment cases, the dissenters who are more progressive are looking at the world from a bottom-up worker perspective and the majority conservative justices are looking at it from a top-down employer perspective. They're just coming at these issues from just very different places.
I mean, one is, and that is, I guess, fundamentally ideological, all right? I mean, the perspective of the idea that there could be something systemic that is taking place. I mean, because, it seems to sort of beg the answer a little bit when you say this thing is so big. I mean, it's just a coincidence that all these women would have less pay. There's no commonality. But of course, you've already mentioned what the commonality is, and that's the basis of the suit, that it's because they're women. And so he's looking for a perpetrator, a specific perpetrator, as opposed to the outcomes of a process.
Right, and it's a very old-fashioned view to see employment discrimination as just resulting from, like, evildoers. The reality is that much of employment discrimination in the workplace today comes from implicit bias, subconscious processes, not where employers are intending to harm minority or female workers, but where just assumptions about those workers become part of the decision-making process. And one of the, problems with Walmart was too big to sue, but one result, according to Scalia, but one sad result is that the decision gives the stamp of approval on subjective employment practices. And those are exactly the areas where discrimination is more likely to flourish. But once you get the stamp of approval to Walmart to engage in these kind of practices, well, then there's every economic and legal incentive for every other company to act like Walmart.
Right. I mean, we're talking about one of, if not, I think, the biggest employer in the country. So if it's a standard that the biggest employer in the country would follow, then why wouldn't everyone else? Now, of course, Scalia is now gone, and things may change fairly dramatically on the Supreme Court in the event that Hillary Clinton becomes the president of the United States. But it would also be fairly dramatic in terms of Trump because, like we say, a lot of those cases are in the hopper already, as people did not necessarily anticipate that Antonin Scalia would leave us so quickly. Well, Michele, thank you so much for your time today. Really appreciate it.
Thank you. Pleasure speaking with you.